Hey everyone, welcome back to Unlawphobic. Today we are diving into a revolutionary change in India's legal system, that is the Bharatiya Sakshya Adhiniyam 2023, or you can say BSA. This law repeals the Colonial Era Evidence Act of 1872 and is set to reshape how evidence is handled in our courts. First up, let's talk about the key reasons why this new law was introduced. So, the previous Evidence Act drafted by Sir James Stephen in 1872 served its purpose, but it failed to address the modern challenges like electronic and digital evidences. 25th of December 2023, the Bharatiya Sakshya Adhiniyam received the President's assent and it came into effect from 1st of July 2024. And this marked the dawn of a new era for evidence laws in India. Act 47 of 2023 is an objective law, or you can say procedural law, that consolidates means the main purpose of BSA is to consolidate and provide general rules and principles of evidence for fair trial. Now we will study about objectives of BSA. These are the main objectives of BSA. So the BSA emphasis on the admissibility of digital and electronic evidences, which is crucial in today's technology driven world, and it aims to prevent miscarriage of justice by ensuring that only reliable evidence is considered in courts, and clarity and uniformity in rules of evidences ensures fair trial across all courts in India. And the act also aims to reduce the litigation cost and time, making justice more accessible, and especially for those who are from marginalized community. It also expands the scope for primary and secondary evidences. Now we will study about what are the applications of Bharatiya Sakshya Adhiniyam. So it applies to all the court proceedings in or before Indian courts. Uh, Whole of India. It means across entire territory of India. And court martial proceedings under military laws like Army Act, Navy Act, or Air Force Act. So, for instance, here in Section 2, Clause 1, Subclause M of Bharatiya Nagarik Suraksha Sanhita, judicial proceeding is defined. So, the definition of judicial proceeding is any proceedings in which the evidence is taken on oath. So, this is the definition of legal proceeding. And the important point here to be noted is that evidence conducted by police is not a judicial proceeding. It means police is not the correct authority uh, in front of which we adduce any kind of evidence. So it only applies to Indian courts or Indian court martials, and it also applies to proceedings before Army Act, Navy Act, and Air Force Act and Indian Marine Act. Now we will study that where it does not apply. So it does not apply, it means like affidavits presented before courts or officers, proceedings before an arbitrator. So section 1 clause 2 of Bharatiya Sakshya Adhiniyam defines that why affidavits are excluded from the scope of this adhiniyam, and the reason being is that deponent because the affidavit is confined to only those facts which deponent is able to produce of his own knowledge and the deponent believes it to be true. So of course court cannot adduce such evidences. It may be relevant sometimes, but it cannot be said to be relevant evidence according to facts and circumstances of the case. A very important landmark judgment related to the scope of affidavits. So, court held in Ayub Khan Noor Khan Pathan versus State of Maharashtra. Uh, this is the case of 2013, and the court held that affidavits are not included within the purview of definition of evidence as has been given. has been given in Section 3 of Evidence Act and Section 2 of BSA. So, filing of an affidavit of one's own statement in own favor cannot be regarded as sufficient evidence for any court of law or tribunal. Affidavit can be a evidence and it can be used in courts, but it cannot be relevant evidence on the basis of facts and circumstances of any case. Now, arbitration or arbitrator. Arbitrators are also outside the scope of Bharatiya Sakshya Adhiniyam, and Bharatiya Sakshya Adhiniyam does not apply on the proceedings before an arbitrator. But arbitrators are bound to follow the rules of natural justice. And the reason being is that the main objective of arbitration process or arbitrator is to avoid the complicated procedure of regular trial. This arbitrator have no power to administer evidences on oath and need not examine the witnesses similar to the court proceedings. They can obtain information in any way as they think fit, but must always give a fair opportunity to all. Thanks for watching the video. We will meet in next video.